Good afternoon, everyone. I'm pleased to extend a warm welcome to all of you here for the Casad Comparative Law Lecture featuring Professor Patrick Glenn. Let me begin by putting this in a larger context. As you probably know, we have a strong international and comparative law program here at the KU Law School. Raj Bala is our Associate Dean for International and Comparative Law, and many members of our faculty, including John Head and Virginia Harper Ho and others, play important parts in carrying out components of the program. We offer our students and the KU law community at large a wide range of opportunities to engage with the rest of the world. These include international and comparative law courses, naturally, but also study abroad opportunities, MOOC core programs, and an array of speakers and organizations. A special feature that we are particularly proud of is the one that we have gathered here for today, the Casad Comparative Law Lecture. I'm pleased that Bob and Sarah Casad are with us this afternoon, along with several of their family members, including their sons Joe and Ben. Also, Joe's friend Susan Rager is with us, and their two granddaughters, Maddie and Bridget. So I ask, as a show of thanks to Bob and Sarah, and to welcome their family members, let's give them all a round of applause. As most of you know, Bob served on this law faculty for a great many years and is now in emeritus status. His work in civil procedure and related areas has a very strong comparative perspective, and his name is known around the world for his scholarly contributions that he made during his career. Indeed, one of the persons who has known about Bob's work for a long time is our speaker today. So let me introduce him. Professor Patrick Glenn holds the Peter M. Lang Chair at McGill University, where he has taught for many years in the areas of comparative law, private international law, and civil procedure. His book, Legal Traditions of the World, now in its 4th edition, received the grand prize of the International Academy of Comparative Law, and this is just one of his many publications. Professor Glenn is a former director of the Institute of Comparative Law and has worked on law reform projects in Russia and China. He is also a member of the Royal Society of Canada and has been a visiting fellow at many institutions, including All Souls College, Oxford. The title of his talk today is The Cosmopolitan State. Please join me in welcoming him to the law school to give this year's Casad Comparative Law Lecture.
Thank you very much, Mr. Dean. Let me begin by saying how happy I am to be here, pleased and happy to be here, and how honored I am to be giving the Robert Casad lecture in comparative law. I said to John Head when he first contacted me about this lecture, "Oh, I know Bob Casad. We've met in many far-off places," which is what I said at the time. Those places are getting to be perhaps more far off in time than they are in space as time goes by, but we have known one another for at least, I think, 2 decades, and I've known his work both in civil procedure and conflicts of laws and conflicts of jurisdiction for a long period of time. So it's a great pleasure to be here, to be giving this lecture, and to see Bob Casad and so many members of his family once again. My topic is the Cosmopolitan State, and I think for most of you that this topic is both novel and obscure. So let me begin by saying what this topic does not mean and what I will not be arguing under this title of the Cosmopolitan State. What I am not arguing, I want to be very clear, is that any state should somehow declare itself to be cosmopolitan, or as my state has done, multicultural in character, as the Germans say, multiculti, with a nicely derisory tone about that, or consociational, or any other such expression designed to capture deliberate diversity of law and legal structures within a state. Least of all am I arguing that any state should declare itself to be multilegal in the sense as some 40 states in the world have done. I found to my surprise that there are as many as 40 states in the world that have no uniform private law, but which adopt various forms of non-state law incorporated by reference into the law of the state. I am not arguing for any of those solutions. I am making a proposition which is more positive in character. How do I therefore arrive at the notion of a cosmopolitan state if I am not arguing for this explicit form of consociational states or multicultural states, or whatever any particular state may designate itself? I think every state must decide for itself the kind of law that it adopts. So I want to make an argument which transcends, or attempts to transcend, those particular state decisions about its own internal law and its relation to the external world. Every state is different from any other. Professor Allott in Public International Law has written of the utter particularity of each state. So far be it from me, or I think anyone else, to say what each state should do in terms of dealing with whatever circumstances it finds itself in. But I do advance the proposition, a more positive proposition, that it is possible to speak of the cosmopolitan state. And what I want to try and do in very short compass with a very large topic is defend 4 propositions, all of which are directed to the general, very, very broad argument that all states are cosmopolitan in character. Most people don't think that's the case, for reasons that I'll explore. So to justify that very broad hypothesis that all states are cosmopolitan, in spite of themselves, in some sense, I have to look in a very detailed way at how different states are cosmopolitan in character. So I'm advancing a very broad proposition which has to be supported in some detailed way with respect to the utter particularity of each state. So 4 propositions. Bear with me through 4. Only 4 propositions. Proposition 1. Today's states are known as nation states. Since I've been here, I've heard the expression nation state used 5 or 6 times. It's widely used in public discourse. It's widely used in the academic world. And it has a nice ring to it. The word state is a little large, a little neutral, a little bureaucratical. It's a little too much like a kind of Leviathan in the language of Hobbes, whereas the nation state has a nice warm feeling to it. This is our state. This is the state of this particular group of people. And it is the case that the expression nation state has contributed enormously to its success. It's short, punchy, and congenial as an expression. The expression cosmopolitan state is not going to be successful. It's too long. It's too complicated. It doesn't compress into a nice bite of sound. But the truth is, I am arguing, is that there never has been and there never will be a nation state. And so it is time we began to face the reality of this situation, that what was essentially a romantic, in the technical sense of the word, French idea in the 18th century, that la nation should have its own legal and political structures, is an idea which has failed. We've been trying this for over 2 centuries now, and it is not the case that there ever has been a successful nation-state, and I say there never will be a nation-state. And we are seeing accumulating evidence of this proposition. Now, this is an interesting empirical proposition, I think. Of course, I take a nation according to its classic definition, which is that it is a homogeneous people, united by language, religion, and even ethnicity. That's how la nation has been historically conceived. So to have a nation-state, which is true to this bringing together, a confluence of the institutions of a state and a people, you have to find a nation which satisfies this requirement of homogeneity. Where can you find a nation-state? And I've been trawling through literature, trawling through data, and all kinds of examples are thrown out as examples of nation-states. Finland is said to be a nation-state because the Finnish language is very unique. It's vaguely related to Hungarian and nothing else. So only the Finns speak Finnish. But the state of Finland is officially bilingual. It's always had, since the state of Finland has existed, a Swedish minority. And if you're in Helsinki and you can't understand the least thing in Finnish on signs in Helsinki, you can get a bit of the Swedish, because it looks a bit like the German, and the German is a bit like the English. But the Finnish is hopeless. But the Finns know that Swedish is an official language. So Finland, like Quebec, is a bilingual jurisdiction. There's not a nation of Finns, because the Finnish state includes speakers of both Swedish and Finnish, and they're both recognized as official languages. Astonishingly enough, Germany is often cited as a nation-state, because Germany has historically looked to ethnicity and hereditary characteristics as in definition of nationality. That's a gross oversimplification, but it is the case that Germany has historically adhered more to a jus sanguinis principle than a jus soli principle. But it's an astonishing proposition, not just in the contemporary state of Germany, which has a vast population of non-German speakers, beginning in the 1950s with the massive influx of people brought in to support the German economy. But historically, Germany has been populated with minorities scattered around the German borders in large measure, including a very large population of Danes in the north of Germany, who are Danish by everything they identify themselves by. So Germany, though it's often cited because of this jus sanguinis principle, is a very cosmopolitan state, and becoming much more cosmopolitan today than it ever has been in the past. If somebody has an example, you must tell me. I'll be crushed if you find an example. But I'm very interested, in the name of scientific pursuit of truth, to know whether someone has another example. Japan is often said to be a nation state, closed in upon itself. But Japan has the Ainu of Hokkaido. And I was in Hokkaido recently, and they've just created a whole new institute for the study of the Ainu and unwritten Ainu law on the island of Hokkaido. And of course, Japan today more and more is becoming a country of immigration, not like traditional countries of immigration. But it's impossible to sustain the proposition that the Japanese islands have been peopled by a single people united in language, ethnicity, and religion. It never has been the case, and it never will be the case. North Korea. Well, getting close. But North Korea, if you look, I'm seriously indebted to the CIA World Fact Book. I never thought I would be indebted to the CIA, but it provides priceless, easily accessible information. So I'm relying on the CIA. If you can destroy the CIA, you can destroy me in some measure. But North Korea has a Chinese population, and historically has always had a Chinese population in some measure. So these are big states, often advanced as nation states, but which fail because they have never been able to overcome the inherent diversity of population on the state territory. So I changed my perspective, and I thought, well, this is because these states are so big. These are all very large groups of population on large territorial expanses. So I went micro. And I think the smallest state in the world is the island of Tuvalu in the South Pacific, that the Prince and Princess of Cambridge are presently visiting, I think. And the island of Tuvalu is a state, juridically equivalent to the United States of America, represented at the United Nations, with a population of approximately 10,000 people. It's a state. And it has 10,000 people. So if you're going to find a uniform population, the chances are higher that you'll find that in a very reduced population. But Tuvalu is a more interesting place than it looks. It's religiously diverse, and it's, of course, linguistically diverse, because there are native languages. There is English, which is why the princess are going there. And so you cannot say that there is anything close to a uniform population in as small a state as Tuvalu. Of course, it doesn't matter how small the minority is. States can look like nation states because the population, by and large, looks the same. Great majority of people look to be linguistically, religiously, ethnically united. But it only takes one person to have a minority problem. The great debate in Europe now is the treatment of the Roms, the so-called gypsy people, and the Rom people of France, who are a population of less than 1% of the French population, and highly mobile, are creating enormous problems for the French government in the European Union. Because the European Union is saying to the French government, you cannot displace these people from their camps by just moving them, and notably moving them outside the country. Of course, the French government is now, even the present socialist government of France, which said that it would never do that when it was in opposition, is now doing that. So they are exporting people. They're doing what is known as ethnic cleansing. This is the dark side of the nation state, just taking measures to ensure social uniformity. And of course they fail in this. They give Rom people plane tickets to go back to where they think these people came from, which happens to be Romania. And so the Roms take the French plane ticket to Romania, they spend a few weeks there, and then they come back to France. Because they're guaranteed mobility in the European Union. So you have a very small group of people, given a French population of 50 to 60 million. But this is the most acute demographic problem and legal problem which exists in France today, for which France is being held responsible by the European Union. So it doesn't matter how big the minority is. There's always a minority. And it's always a fundamental problem, a principle of how minorities can be dealt with. So I draw the conclusion that there are no nation states. There never have been, there never will be. All states are therefore cosmopolitan. And the most successful states are the states that have been most successful in dealing with their own internal diversity. States such as the United States of America and France. I have it on no lesser an authority than Justice Scalia of the United States Supreme Court, who said in Employment Division and Smith, the United States is a cosmopolitan nation. And you then discuss what consequences that flow from that. But the key judicial statement of a judge of the High Court of the land is that this is a cosmopolitan nation. Of course, he meant state. There is no nation. This is a cosmopolitan state, because we've succeeded in most of the time, on most questions, to have the people here think in terms of what Habermas calls in Germany constitutional patriotism. Most of all, we do not turn upon one another. Most of all, we collaborate in this enterprise of overcoming diversity to work together in some kind of successful manner. So the nation states, the states that have been seen as most successful as republican enterprises are, in a sense, paradoxically, the states that have been most successful in dealing with their cosmopolitan character. Proposition 2, we're a quarter of the way there. It is possible to be cosmopolitan without being universal. And I say this because in the world today, there is a very rich and very impressive literature of so-called cosmopolitan theory. In the UK, it's David Held. In this country, it's Thomas Pogge of Columbia and Martha Nussbaum of Chicago. And these are philosophers, political theorists that are advancing with great subtlety and great distinction the idea that we should think about the world in terms of cosmopolitanism. And what that means for them was best expressed by Diogenes in Greece, who said, and I accept that he said it, though there's a question of what he meant, I am a citizen of the world. These beautiful, classic, ringing statements. And cosmopolitan theoreticians say today, we should regard each individual as a citizen of the world. Each citizen should be treated on an equal basis with every other citizen of the world. And essentially, therefore, we should be engaging, most notably according to Thomas Pogge, in revenue distribution through the world, and we have to find some way of doing this. So the cosmopolitanism which is being circulated today has enormous implications for our present notions of national law and states as sources of law and normativity in given territories of the world. There's a real debate about what Diogenes meant, because there are some people who say Diogenes said this, but he was a cynic, with a capital C, and cynics were those kinds of people, didn't believe in anything and rejected all kinds of authority. So when the citizens of the city of Diogenes came to Diogenes and said to him, these are the responsibilities of the citizens of this city, Diogenes would have said, I am a citizen of the world, which is a quite different context from the context usually given to the statement by cosmopolitan theoreticians. And there are some French encyclopedias of the 18th century that defined a cosmopolitan as a bad citizen, because the cosmopolitan, by definition, was someone who shirked local obligation in the name of larger forms of obligation. But my argument is that one can be cosmopolitan without being universal in character. In a sense, the word cosmopolitan, I won't say hijacked, I won't say has been hijacked, but has been taken over or has been adopted by cosmopolitan theorists, and it overlooks what is the usual meaning of what it is to be cosmopolitan. The word is defined in dictionaries as being common to or compatible with different countries, which is how the word cosmopolitan is understood generally in the population. The last person I have read that has defended this ordinary language concept of cosmopolitan was Stephen Toulmin, who in the mid-20th centuries argued that cosmopolitan means what the word indicates. And it's a combination of cosmos, hence cosmo, and polis, polity. And what it means is that you can have a harmonious bringing together of the cosmos and a particular polity. It is a notion of harmonious coexistence rather than a notion of obligatory universality, which is the way it is being presented by contemporary cosmopolitan theoreticians. So I put to you the usual garden variety cosmopolitanism and say to you that the cosmopolitan state is not a state of domination which is going to impose its law on the rest of the world. The cosmopolitan state, which is a successful one, is a state which is dealt with most successfully its internal and external diversity, the inevitable internal and external diversity within which states actually function. So there is no cosmopolitan universal law, but there are cosmopolitan attitudes and cosmopolitan methods and cosmopolitan officials who know how, in the utter particularity of each state, how to reconcile exception claims with claims for application of the law and normativity of the majority. And of course you have to walk a tightrope. You have to walk with the majority and you have to walk with the minority at the same time to be successful in this game. In one of the sessions I was in this morning, we decided it was necessary to avoid radical dichotomizing language, which is unfortunately engaged in, I think, too often in the public sphere. So, cosmopolitan states, yes, this may contribute to a more cosmopolitan world in the language of cosmopolitan theorists, but it doesn't have to. It's not the case that there is some kind of inevitable evolution towards some form of world government, regional governments, or world federalism of some kind or another. So that's Proposition 1 and Proposition 2. Proposition 3 is more comforting, I think. Proposition 3 is, don't worry about any of this. It is the case there is a lot of angst in the world and a lot of antagonistic discussion about globalization, foreign influence, empires, hegemonic behavior, terrorism, and all of the things that occupy us in the present state of the world. Of course, there's reason to worry about acts of violence, which creates difficulty, but a large measure, some of the violence in the contemporary world, I think, can be related, I have no proof of this, to 300 years of teaching that the ideal is a nation state. If we've been teaching populations that for 300 years, people are going to accept that as true, and they're going to object to human diversity within their state. We can't fault people for accepting orthodoxy of instruction, that states are nation states. If their state is not obviously a nation state, they feel they are quite correct in objecting to measures which have brought about that situation. So you have a kind of reaction in the high circumstances of high population mobility today on the part of local populations towards recently arrived population. It's everywhere the same phenomenon going on, and that's to be expected because this teaching has been out there since the time of the French Romantics. One should worry about the violence that is happening. One way of getting across the violence is to abandon the notion of the nation state. We've got to get the message out there that it's necessary always to live with human diversity because it's impossible to do otherwise. So we should not worry about the general phenomenon that the state is losing its place. in the phenomenon of what we call globalization, which is all of these constituent parts of one kind or another. I've been very impressed recently reading a book by someone named Lawson. I can't remember his first name. And the title of the book, to have a successful book, you've really got to work on the title. You've got to have a title which is catchy. And the title of his book is Closure, The Answer to Everything. You're going to get readers of that, no matter what you say in that book. Just in case Lawson may have discovered the answer to everything. Why does Lawson say that closure is the answer to everything? And when I read this, and it was hard reading, it's one of those books with no footnotes, and paragraphs that go on for 2 pages, and so on, a typical political theory book, I said, this is obviously relevant to the kind of problems that I've been worrying about. Lawson says 2 things. Closure is the answer to everything. One, because the only way we can understand the world is to effect some kind of closure. If you want to do anything, you want to think about anything, you have to narrow the focus. You've got to decide, this is your problem. This is your unit of political construction, or law, or legal problem, or whatever it is. So nobody can function epistemologically without a form of closure which allows you to think about something. You've immediately thereby effected a closure around the concept of what that something is, whether it's a physical object, a concept, or anything else. So that's an interesting proposition. But the more important part of Lawson's project is to say that closures can never be definitive. Closures can never be definitive because when you're effecting a closure, you're always effecting a closure around something which is part of a much larger field of what he calls texture. You're faced with texture, undistinguished texture. To understand everything out there, you effect a kind of closure. But the closure you effect is surrounded in an ongoing way by texture beyond the closure you've effected. And that texture beyond your closure is an ongoing incitation to new and different forms of closure. So no closure can be definitive. You could theoretically have a definitive closure if you could have closure of everything. But that wouldn't improve things because everything would just be inside as opposed to outside. So no closure can be definitive because the closure that you effect is subject to the ongoing attraction of the texture you have not included in your initial enclosure. And I said to myself, that's the answer to everything. By George, he's got it. Because the state is a closure. We had states which were explicitly very cosmopolitan throughout much of European legal history. You had ecclesiastical law running across what are now state borders. You had commercial law running across state borders. And then you had a period of state construction, which can be described as a kind of imposition of a cookie cutter on all those horizontal webs of law running across Europe and actually running across the Atlantic. Somebody's written a book called The Atlantic Constitution recently, trying to describe this phenomenon of exchange of information over the Atlantic between colonizing countries of Europe and North American forms of settlement. So we've known the construction of the contemporary state as a form of closure effected through this imposition of boundaries on law which previously ran across these forms of boundaries. Before that, there were other forms of closure. So we've had closure around tribes as the major form of legal and political organization. Tribes have significantly lost their significance, but tribes are still with us. It's the case we know in North America that North American state law recognizes the law of Aboriginal peoples, and we argue about how much it does so. But it is the case that the United States of America, Mexico, and Canada all, in some measure, recognize the law, unwritten law of the populations that were here before the Europeans. So there was closure of tribes as the major form of organization. It's become less significant. It's given way to other, more tempting forms of closure. And we've had closure around the manor in feudal times. It was the basic form of organization of feudal societies. Well, I don't know whether you've seen any effective manors operating lately, but the manor has lost its significance. The manor gave way to city-states. City-states is what they're called, because this was a form of political and legal organization meant to be self-sufficient in large measure. And the city-states and the manors gave way to kingdoms. And there were even so-called absolutist kingdoms, such as that of Louis XIV, the Sun King. But those kingdoms couldn't resist other forms of closure which emerged from the texture surrounding them. So we saw the emergence of the contemporary state as a territorially bounded, exclusive source of law for what is meant to be a uniform population within it. And what we're finding now is that the contemporary state is losing its grip. States themselves are tempted by texture beyond themselves. So states today recognize arbitration, for example, whereas in the 19th and early 20th centuries, arbitration was seen as contrary to state public policy. States now see arbitration as an ally in the process of dispute settlement. So the state's exclusivity in dispute resolution has been abandoned in favor of adoption of the texture of private resolution of disputes, particularly in the form of resolution of commercial disputes. So the state is today declining. Don't worry. Something will take its place. We don't know what it is. Maybe even there isn't anything left to take its place. We won't have a world government. Kant was very skeptical about a world government. His idea of a cosmopolitan law was simply a right to travel from one place to another. It certainly did not involve world government or world law. So we may not have anything beyond the state. It may be that we've tried all of these things, realize we can't get rid of any of them. They're all still with us in some measure. There's no progressive evolution. It's the case that we keep multiplying ways of organizing collectivities, and it may be that there's nothing beyond the state. So we would just accept the existence that states are as good as it gets, and the most successful states are cosmopolitan ones in dealing with manifest human diversity as it exists everywhere. Now, I don't know when I started. When did I start? 22? I'm getting near the end, though, aren't I? I should know that I'm getting towards the end. So let me make the fourth and final, advance the fourth and final proposition, which that given what we call globalization, whatever that is, and over which no one is in control, nobody can stop globalization. It's just going to play itself out, whatever it means. States are becoming more and more evidently cosmopolitan in character. And generally, I think this is a salutary development. It means we should start teaching people that they should not be engaging in ethnic cleansing or even genocide, which have been undertaken as a means of ensuring homogeneous populations. We should be teaching that it's as good as it gets in having a state which is successful in its own way of dealing with inevitable human diversity. How are states becoming more and more evidently cosmopolitan? Let me advance three ways: cosmopolitan citizens, cosmopolitan sources of law, and cosmopolitan logic or thought. Cosmopolitan citizens. Winston Churchill, I have read, once said that a person can have no more have more than one citizenship than they can have more than one mother. This is just an impossibility to have two citizenships. But today, that notion of exclusivity of citizenship is in rapid decline. Some states are insisting on it. The Netherlands recently went back from duality of citizenship to single citizenship. You may have read the influence of the far right in the Netherlands. We spent a year in the Netherlands 2 years ago. But Wilders, the far right political person, just essentially lost the last election in the Netherlands. So it may well be that states which have gone back to unique citizenship may reevaluate that and join in the very general tendency in the world to recognize multiple nationalities. In part, this is because of theoretical objection to what Amartya Sen has called, in his new book, the idea of justice, the evil of unique categorization of people. He says if you insist on categorizing people only one way, conflict is parasitic on unique categorization of people. If you're going to say that all of these people are only this, and all of those people are only that, that's a built-in recipe for violent conflict. And this is a very interesting proposition, but what we're seeing in the law of citizenship over jurisdictions is that more and more jurisdictions are saying we refrain from imposing a single citizenship on our people. We're more and more willing to tolerate multiple national loyalties. And multiple national loyalties are a cosmopolitan way of thinking about human identities. In some places, this is the case that it's not a question of having multiple citizenship. It's a single category. It's a single concept. People are now talking about denizens. And it's been said in the United States by specialists in citizenship, there's a whole range of citizenships. People who are not full citizens but not aliens. And they're here and they have different entitlements to state law, to federal law, and therefore we don't know a single category of citizenship in the United States because there are so many gradations in the rights and obligations that people can have when they're here legally and even illegally residing in United States territory. So it's not only multiple citizenships, it's gradations within the notion of citizenship. And the word I've found most frequently used, this idea of denizens, which is an old word which is meant to deal with someone who is neither here nor there, and it straddles the dichotomy between citizen and non-citizen. A second way in which states are becoming more obviously cosmopolitan sources. And I think this rings a bell, because I understand there have been about 3,000 law review articles written on the United States Supreme Court citing of foreign sources. What's happening, of course, is that judges on the Supreme Court do it. And then we have a great debate about whether they should be doing it. But some of them keep doing it. And what they're doing, those that do it, of course it doesn't matter whether they're majority or minority, because the information is there, and it's then a question of what is done with it. What those people are doing is reminding the jurisdiction and the rest of the court that there are these different views on the matter in question. So there is a reality, in spite of the wonderfully rich debate for and against, of the United States Supreme Court citing foreign sources. You don't have to be cosmopolitan that way. That's the way the debate plays out in the United States, where judges cite things and are free to cite things and are free to cite what they choose. The French Court of Cassation cannot cite cases. All the French Court of Cassation can cite is the text of French laws. And so you have a very strict form of judgment writing in the French judicial tradition. The French Court of Cassation has become an extremely cosmopolitan court without citing any non-French materials. And we have this on record of presidents of the French Court of Cassation. Before deciding any case which is important in law, they engage in massive research. They have a huge research department within the court on the law of other European countries. This is on questions of pure French law. the law of the United States of America, and further abroad, if necessary. So the French Court of Cassation is a cosmopolitan civilian court which doesn't engage in the kind of expository judgment writing that the United States Supreme Court does, but it has become an extremely cosmopolitan court. It doesn't cite foreign sources, but it may well be a more cosmopolitan court than the United States Supreme Court, which does cite foreign sources. So you have to look at what is actually going on with the information you can obtain in order to discover how the cosmopolitan character of the jurisdiction is playing out in the utter particularity of each jurisdiction. I recently had the privilege of supervising a doctoral thesis of a French student looking at French and Quebec law on how French private law, civil law judges deal with religious law claims. And of course, France is a country of secularité, laïcité. In France, there's only the law of the French state. But French judges get seized with these cases because there's such a large population that sees religious law as normative, whatever the religious character is. So French judges have to deal with these cases. How do they deal with these cases since they can't apply religious law? They're very sophisticated, though you have to get through all of the ways in which they deal with this. For example, they subsume, is the language of my doctoral student, religious law claims as civil law claims. So if it's the case that there is some assumption of an obligation imposed by religious law by a party, you can treat that as a civil law contractual obligation. And off it goes as a civil law contractual obligation, even though from the party's perspective, it's a claim eventually founded on religious law. Or there was the most astonishing thing I discovered. When claims are made before a French private law court which are ultimately based on religious law, what the French judges do is convert religious law to fact. They speak of le fait religieux, the religious fact. And then they decide the case on the facts before them. But they're not enforcing foreign law or religious law. They're just deciding on the facts. And if someone wants to change their French name to a Muslim name because they're converting to the Islamic faith, then they have an interest in the changing of the name, and therefore that interest is a fact which can be appreciated by the French court. So the French court will order the French executive to change the name of that person. And so you have extremely subtle intellectual devices being engaged in by these judges who must respect publican secularity, but who are also, as judges, required to do justice between the parties. And they do. And part of the discussion we had earlier today, I think it was pointed out that you can enact laws and you can enact prohibitions, and the question is always then what happens to those laws and prohibitions in the incredibly complex circumstances of individual litigation. And the third way in which states are, I think, becoming more cosmopolitan in their operation is what I am calling the development of cosmopolitan logic. How do you think about these problems? And of course, Western lawyers and Western people generally have been taught to think in terms of classical logic. And there are so-called laws of thought. The law of non-contradiction. You cannot assert contradictory propositions. That's not thinking like a lawyer. And the law of the excluded middle. A or not A. Between two contradictory propositions, there's no middle ground, say the logicians. This is very depressing news for lawyers, faced with the task of desperately finding some kind of middle ground. Why is it logically the case that there is an excluded middle? It flows from formal logic. Take me as an example. I am Patrick Glenn. From my perspective, the rest of the world is not Patrick Glenn. So it becomes logically Patrick Glenn or not Patrick Glenn. And there is an excluded middle. There's nothing between Patrick Glenn and not Patrick Glenn. And why is that logically necessarily? Because not Patrick Glenn starts right here. And it just goes forever. It's galactic. And the not Patrick Glenn eats up all possibility of a middle ground. The way you have defined the contradictory propositions, A or not A, means you have excluded any possibility of a middle ground. And for 100 years, logicians have been telling us this is how you have to think once you have contradictory propositions. But there is what's being called a new logic, or even new logics in the world. I just discovered, to my chagrin, but pleasure, eventually, that there's a 700-page volume published recently called The Many-Valued and Non-Monotonic Turn in Logic. And it's impossible to read it in a lifetime. You sort of spend 2 days on one page, all of these complicated formula. But to summarize that book for you, what it says is that we don't have to take the so-called law of the excluded middle as seriously as it has been said to be necessarily taken. And that's because we no longer accept A and not A as being mutual exclusive propositions. You can have what they call a multi-valued logic. A and not A can both be taken to be true. You can accept contradictions and live with them. You can accept a right of freedom of expression and a right of privacy. And everything then depends on where particular cases are situated within those contradictory general principles. And logicians are beginning to recognize that the real world is much more subtle than a world composed of A's and not A's. It really is possible, as legal practice tells us, to find included middles. And the more and more populations are diverse, the more and more contradictory propositions are advanced, the more and more I think we have to think in terms of cosmopolitan logic, but it's right there. This is what the new logics are teaching in very abstract, difficult to understand forms, but we no longer need be concerned with thinking like lawyers the way lawyers were taught to think. So it's an age of rethinking. Thank you very much for your attention.